Good morning, everyone. My name is David Barish. I'm the chairman of the Pennsylvania Gaming Control Board. Before we begin, once again, I'd ask people to put their electronic things on silent. With us today is Fred Strathmeyer, representing Russell Redding, Secretary of the Department of Agriculture, Jen Langen, representing Jay Torcella, the State Treasurer, and Bob Coyne, representing Acting Secretary of Revenue, Dan Hassel. Thank you all for coming. Quorum of the board being present, I'll call the proceedings to order. First order of business, Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Thank you. Today we have an oral argument and a public hearing scheduled. The oral argument pertains to Louis DeNaples' petition for determination regarding the Gaming Control Board orders of September 23rd, 2009 and June 13th, 2012. The public hearing pertains to the joint petition by Eldorado Resorts, Inc. and Isle of Capri Casinos, Inc. and the related entities for prior approval of a transfer of interest in the management company for a Category 3 licensee, Woodlands Fayette LCC, owner of the Lady Luck Casino in Nemacolin. Could we have counsel for the DeNaples petition to please come forward? Thank you. Mr. Grad, if you would state and spell your name for the court reporter.
Joseph Grad, G-R-A-D.
Thank you. Before we begin, Mr. Grad, I just want to be clear about what exactly the relief is that you are seeking here today. First, we are dealing with two board orders, as we mentioned, relative to Mount Airy 1, the ones from September 23rd of 2009 and June 13th, 2012. Is that correct?
Correct.
And as we read your pleading, the relief you appear to be seeking is you're requesting this board to hold that those orders of September 23rd, 2009 and June 13th, 2012 did not prohibit Mount Airy from transacting business with a company in which Mr. DeNaples had an ownership interest. Is that correct?
That is correct.
So would you agree that in order to be granted the relief that you seek, specifically that the companies owned by Mr. DeNaples can conduct business with Mount Airy, notwithstanding the two orders that are currently in place, that this would require a qualified majority of this board to vote in favor of granting the relief that you're requesting?
That's correct.
Thank you. And if you are successful in obtaining the relief you request, this decision will not lift any part of the orders in question, but will instead establish how certain conditions in that order should be interpreted by the board, its staff, Mount Airy, the public, etc. Is that correct?
That's correct.
Thank you. Okay, you may begin.
Okay, thank you. Mr. Chairman and members of the Gaming Board, my name is Joseph Grad, and I am here on behalf of the petitioner, Louis DeNaples. We are here today seeking a determination that the board's September 23rd, 2009 order and June 13th, 2012 order do not prohibit Mount Airy Casino from transacting business with a corporation in which Mr. DeNaples holds an ownership interest. The relevant condition is found in both orders, paragraph 13 of the 2009 order and paragraph 5 of the 2012 order. We believe the condition limits Mount Airy from providing Mr. DeNaples with principal-type compensation, casino profits, compensation for executive services. There is no basis to conclude that the condition extends beyond principal-type compensation so as to prohibit Mount Airy from transacting business with DeNaples Company. The text of the condition refers only to Mr. DeNaples as an individual and contains no mention of Mr. DeNaples' ownership in any companies, nor does it mention the transacting of any business. In 2009, this board was well aware of the DeNaples companies and had drafted specific conditions related to them. If this board truly wanted to restrict Mount Airy from doing business with the DeNaples companies, the board would have drafted a simple, unequivocal statement of condition to that effect. The context also provides insight. The condition was imposed in the context of Mr. DeNaples being a principal licensee and transferring sole ownership of the $700 million casino to his daughter Lisa DeNaples Trust. As Mr. DeNaples was a principal at that time, logic would suggest that the condition applied to his rights as a principal licensee. This is not only my belief, it was also the belief of the board's Deputy Enforcement Counsel during the May 23, 2012 hearing, when she stated the following: OEC is of the opinion that the restrictions and conditions implemented by the board's September 23, 2009 order will require the licensure of Louis A. DeNaples, and as such recognize such restrictions and conditions remain in place until such time that Louis A. DeNaples has submitted an application for a principal licensure and the board has issued such a license. That's about as clear as it gets. The condition applies only to activities which would require Mr. DeNaples to obtain a principal license. No license, especially not a principal license, is required for Mr. DeNaples or any other individual to be the owner of a gaming service provider. And I didn't cherry pick this statement from the record. This is the only statement from the 2009 and 2012 board hearings that articulates the scope of the condition, and it clearly supports the relief we seek today, that the condition does not apply to the DeNaples companies. And perhaps most importantly, the subsequent actions of the board are wholly inconsistent with the interpretation that the condition applies to the DeNaples companies. From September 2009 to June 2012, while the condition was in effect, Mr. DeNaples continued to be a licensed principal, continued to bankroll the casino, continued to inject over $35 million of needed cash to sustain its operations and fund the table games expansion. So while the condition was in place, Mr. DeNaples was engaged in regulated activity before this board at the highest level. So it defies common sense and basic licensing principles to believe at the same time that he was restricted from engaging in activity with Mount Airy, which required no license and perhaps no investigation at all. And finally, let's turn to the board's final action with respect to Mr. DeNaples as a licensee. After Mount Airy restructured in 2012, so that Mr. DeNaples was no longer needed to be a lender and principal of Mount Airy, the board allowed him to withdraw his principal application without prejudice. In doing so, the board granted Mr. DeNaples a clean slate for the highest level of licensure before the board. If Mr. DeNaples has a clean slate for the highest level of licensure, it is only fair that the condition be interpreted so that he has a clean slate for the lowest level of licensure, an ownership interest in a gaming service provider that wants to engage in business with Mount Airy. Accordingly, I request that this board grant Mr. DeNaples' petition and determine that the board's orders of September 23, 2009 and June 13, 2012 do not prohibit Mount Airy Casino from transacting business with a corporation in which Louis DeNaples holds an ownership interest. Thank you for your consideration.
Thank you. Enforcement Counsel?
Good morning, Chairman Barish, members of the board. David Tepper, T-E-P-P-E-R, Assistant Enforcement Counsel with the Office of Enforcement Counsel. Louis DeNaples is asking the board to permit companies with which he has an ownership interest in to do business with Mount Airy Casino. More specifically, Mr. DeNaples is requesting that the board reinterpret long-standing board orders which prohibit him from conducting...
Sorry, can you move either closer to the microphone, or Doug, can you turn it? I'm having trouble hearing you.
Is this better?
Yeah.
Thank you. Mr. DeNaples is asking the board to permit companies with which he has an ownership interest in to do business with Mount Airy Casino. More specifically, Mr. DeNaples is requesting that the board reinterpret long-standing board orders which prohibit him from conducting business with Mount Airy. Since May of 2011, Mount Airy No. 1 LLC has petitioned the board several times with the same request, which has been ultimately denied. OEC respectfully requests that the board come to the same conclusion today. This matter arises out of Mr. DeNaples' former ownership of Mount Airy Casino. Mr. DeNaples was the sole owner and principal licensee of Mount Airy when it was initially issued a Category 2 slot machine license in 2006. Mr. DeNaples' principal license was suspended by the board in 2008 Following Mr. DeNaples being charged by the Dauphin County District Attorney with perjury based on sworn statements Mr. DeNaples made to the Board's Bureau of Investigations and Enforcement during the background investigation for his principal license in 2006. The Board subsequently turned over control of Mount Airy to a trustee appointed pursuant to the Act and placed conditions on Mr. DeNaples that prohibited from receiving any compensation, consideration, or distribution generated by or related to slot machines or amenities located at Mount Airy during his suspension. In 2009, the Dauphin County District Attorney's Office withdrew the criminal charges against Mr. DeNaples, and the Board lifted the suspension of Mr. DeNaples' principal license. However, the Board kept in place certain conditions, including the condition prohibiting Mr. DeNaples from receiving any compensation, consideration, or distribution from Mount Airy. In 2012, the Board approved a corporate restructuring of Mount Airy, whereby Mr. DeNaples would transfer his ownership interest in Mount Airy to his children. Mr. DeNaples' principal license was permitted to expire. However, the Board kept in place a prior condition that prohibited Mr. DeNaples from receiving directly or indirectly any remuneration, cash, or property distributions from Mount Airy. In 2013, Mount Airy filed a petition with the Board requesting the same relief which petitioner requests today. Mount Airy argued that the Board's conditions only related to Mr. DeNaples personally, but did not include or reference entities in which Mr. DeNaples has an ownership interest. Therefore, Mount Airy opined that this condition does not prohibit Mount Airy from contracting with a business in which Mr. DeNaples has an ownership interest. OEC recommended that if the Board were to modify or lift the condition, that due to Mr. DeNaples' unique history before the Board, being criminally charged with perjury for statements made to the Board's Bureau of Investigations and Enforcement during his initial background investigation in 2006, that he be required to submit an application, be vetted, and be found qualified prior to Mount Airy conducting any business with a company in which Mr. DeNaples has an ownership interest. Following a hearing before the Board and further negotiation between the parties, an agreement was not reached regarding the scope of a background investigation of Mr. DeNaples. As a result, the Board issued an order dated March 20th, 2014, denying Mount Airy's request. The Board's order stated that under the unique circumstances of this case, the Board will not authorize Mount Airy to do business with an entity affiliated with Mr. DeNaples, given the Bureau of Investigations and Enforcement and the Office of Enforcement Counsel's objection to the relief requested, without some level of vetting of Mr. DeNaples. In its order, the Board noted that it would reconsider the issues raised if Mount Airy, BIE, and OEC came to an agreement regarding the scope of a background investigation of Mr. DeNaples. Although Mr. DeNaples may argue that the Board's condition would include a prohibition of any of the corporations in which he holds even a single share of stock, the Office of Enforcement Counsel is of the opinion that this assertion places form over substance. Since 2008, the Board has kept in place a condition that Mount Airy may not receive any compensation, that Mr. DeNaples may not receive any compensation, consideration, or distributions from Mount Airy, either directly or indirectly. Although in the past it has been Mount Airy that has petitioned for relief from this condition, Mr. DeNaples is here today asking for the same relief. This is essentially a second bite at the apple. As a result, OEC requests that the Board deny Mr. DeNaples' request. However, if the Board decides to grant the relief requested, the Office of Enforcement Counsel has maintained and continues to maintain that prior to Mr. DeNaples or any companies in which he has an ownership interest in conducting business with a licensed facility and pursuant to Section 1317.2d of the Act and Section 437A.1 of the Board's regulations, the proposed company file an application for certification as a gaming service provider and Mr. DeNaples file application as a qualifier, that no emergency or interim authorizations be granted, that Mr. DeNaples be vetted through the background investigation process and be found qualified by this Board prior to any authorization to conduct business. Thank you.
Thank you very much. Mr. Grad, do you have any rebuttal at this moment?
I would just want to say that a lot of the previous petitions, almost I believe all of them, dealt with the modification of the board orders. We're not seeking a modification. We are seeking a determination of this board with respect to the interpretation of these conditions.
Okay.
And with respect to reinterpreting, I would respectfully suggest that OEC has reinterpreted this condition. When this condition was put into place in 2009, 2012, there was no mention before this hearing that these conditions applied to the DeNaples companies. Now, after the fact, when Mr. DeNaples and Mount Airy have come back to have this limited engagement with the board, now they've come up with this interpretation.
Okay. Anything further from Enforcement Council at the moment?
Solely as to our belief that the directly or indirectly provisions directly address the companies that Mr. DeNaples owns, and that we believe that indirectly means that benefit.
I understand. Are there any questions from the board, comments at this time?
One question. Thank you, Mr. Chairman. Mr. Tepper, twice you mentioned I think it was 2009 Dauphin County case where, and I'm not being an attorney, I'm going to go out on a limb here, it was an indictment? Is that what you mentioned?
It was criminal charges being filed.
What was the outcome of that?
The charges were ultimately withdrawn by the Dauphin County District Attorney's Office.
Thank you.
If I can, Mr. Gren, is it your understanding that the condition against the business contacts that apparently are being pushed now are prohibited, at least as far as Mr. DeNaples himself is concerned?
You mean Mr. DeNaples' personal involvement?
Yes.
Well, in my interpretation, if Mr. DeNaples would be directly involved, he would be providing management services or executive services, and he would be licensed as a principal, or be required to be licensed as a principal.
So you're seeing a distinction between Mr. DeNaples personally and his companies?
Yeah, and the regulatory scheme is based upon that. It's based upon not that you ultimately receive money, but it's in what context you receive it. So if you got $30 from a revenue share from a casino, you're required full licensure. If you get $30 from a company that does business with the casino, you have to do nothing.
Even if you are the controlling shareholder of that company in this situation?
Sure. I mean, in terms of the gaming service provider context, it has to do with the money, the goods or services, and the compensation for those goods or services flowing to the gaming service provider. Under $100,000, there was no investigation. That does not prohibit OEC from coming to this board if a DeNaples company or any other company does $1 of business and requesting the board require them to fill out a vendor certification form. But the regulatory scheme in place does not require anything below $100,000.
All right, thank you.
I do have a couple of questions. First of all, the preliminary question of standing and the real party interest. Shouldn't the companies here really be petitioning us today instead of Mr. DeNaples? How would you respond to that?
Well, I think I would respond under the principle of res judicata, that this board had already granted Mr. DeNaples standing with respect to modifying the the September 23rd, 2009 order and the June 13th, 2012 order. So that standing had already been granted, and Mr. DeNaples is personally identified in this condition, and it prohibits him from engaging in a business activity of a facility that he envisioned, owned, financed, and built.
Which we're not modifying again.
You're not modifying the condition. We're asking simply for a determination regarding the scope of a condition in which Mr. DeNaples is personally named.
Okay. I was interested in your commentary about counsel for OEC and comments that he made. My sense is that OEC can make lots of comments, but the board, just like you can, both sides, but the board, of course, then makes the ultimate decision. And how do you respond that we're bound by what OEC?
I don't suggest that you're bound by it. I would suggest that the board ultimately sided with OEC's position in that case, and OEC, that statement was close to, if not literally, the final word on this matter before it was cemented into place. So no, I don't believe. I don't believe it's binding. I think it's context. It's you sided with OEC's interpretation. That was their interpretation at the meeting. There is no other statements in the record that articulate the scope of this condition. That's all we have. All we have in the record from 2012 is OEC's statement on the matter.
How do you deal with the plain meaning interpretation of the words directly or indirectly? I'm interested in that because I've been bothered by indirectly indicates to me that an individual may be able to receive benefit, could be behind a corporate shield or whatever, but
Sure.
still money comes to them.
I think that under the principal regulations that, for example, I think that if there was a company set up, okay, and that company distributed profits and then ultimately distributed profits to Mr. DeNaples without Mr. DeNaples having a principal license, that would clearly violate the condition. You know, it would be a circumvention. Clearly, I don't know if Susan Hensel's here, but she would view that as being a principal.
And if I understand it too, you would take the position, should this be granted, that and should the threshold amount of business done in the ensuing year be below 100,000, that OEC would not be permitted to do any kind of inquiry or examination of your client?
Well, the regulatory scheme is in place, which requires no vetting. But there's also, that's the default. But there is a provision in the regulations that require the board, OEC can come before the board and seek relief, you know, to full gaming service provider certification if there is a finding by this board that that's required.
Right.
That's simply
in the
what-
interest of the broader scope of Title IV of protecting the Commonwealth and its citizens.
Sure.
Okay, thank you.
Yeah. So when you talk about the Naples affiliated corporations, what's that mean? What do they do?
I didn't, I think Mr. Tepper might have. I spoke just simply to
But that's part of the
the
petition.
Naples
Is that you?
companies, basically that, I didn't say affiliated. My point is ownership, that Mr. Naples has an ownership interest.
Okay. So what are they?
So what are
They
the
supply paper? Do they remove
I
snow?
don't,
Do they
you know,
do accounting?
honestly, I can't tell you what garbage removal, snow plowing. Those are, you know, certain things I've heard of that have been even before this board. That
Shouldn't you know those?
well, I'm seeking a determination simply that the condition allows him to do business. I'm not privy. I'm not.
don't-
I'm
you
his
could only-
attorney. I'm his attorney. I don't. I can say that. I can say
You're
that
his
they're
attorney
non-gaming,
representing the.
that they're non-gaming
If
services.
you would,
Wait a while.
please allow
Oh,
the
sure.
commissioner
Sure,
to
sure.
frame a question.
If I understand the petition, it's that Mr. DeNaples is an officer and owner of several Pennsylvania corporations. Is that true or not true?
True.
Okay. And that he wishes to do business with Mount Airy on several businesses, and it's been defined to me, I may be wrong, as affiliated corporations. All I'm asking is that can you tell me, I mean, you said maybe snow removal, maybe garbage. I mean, can you, I would hope that you would know what those companies are.
I do. I mean, I'm not an executive or a business person within his organization. I'm simply his lawyer. I do know that garbage removal, cleanup of the roads, replacing the golf carts at the golf facility, overall, you know, exterior maintenance. Nothing that revolves around gaming equipment or the gaming operations.
Okay.
I'm sorry if I interrupted you.
That's all right, no problem. And you used the word unique in describing the history, the business relationships, probably 3 times, maybe 4. Why do you use that word?
Mount Airy and Mr. DeNaples present a unique situation to this board. First, Mr. DeNaples is the only principal licensee that's been criminally charged for perjury in statements made to the board or its staff members. In addition, Mount Airy is the only privately held casino that is held by one family and initially held by one individual.
Okay.
Okay. I have one clarifying question after Commissioner Logan's inquiry. Whether you know all the entities or not, if we clarified the order in the way in which you want it clarified, is there anything that would prevent him from creating 10 other entities, providing 10 other types of businesses, and still come under that same rubric of protection? Would our clarification open the door to any number of other supportive services being provided by yet to be created DeNaples controlled entities?
Well, I don't think the issue is newly created. I don't think, one, that's not the plan.
I don't.
Right, that's what I'm saying. But I think the question is, are those companies, whether they're new or existing, whether they're providing bona fide goods and services to the casino?
I'm asking a much more
Yeah, I mean, I guess I'm.
tightly drawn question, which is, had you been able to list the specific entities and the specific services, we might have a different conversation. But let's say there are 3 such entities doing snow removal, whatever it is. Once this order was clarified in that fashion, the order would apply to any DeNaples controlled entity that might come into existence to provide other services to Mount Airy. Is that true?
I guess I think it would, but I guess if you're, I mean, would have no objection to an order clarifying that.
I'm just trying to understand the scope and impact of a potential decision that we might make. We're not really, from your perspective, if we were to give you the relief you wanted, it would not only affect the currently existing DeNaples controlled entities, okay, but any other entity that might be created down the road. Is that correct?
That's correct.
Thank you. That's all. Should we take a break now?
Mr. Chairman, may I?
One second, please. One second. I think. I'll give him a chance to clarify.
We'll give him a chance.
Please, go ahead.
If I may clarify a few statements, including an answer to Commissioner Logan's question. Unique isn't solely a term used by the Office of Enforcement Counsel. The unique circumstances of this case is a direct quote from this board's March 20th, 2014 order. In addition, in regards to the principal license comments in 2009, the 2009 comments represent a snapshot in time where Mr. DeNaples was before the board not as a potential GSP qualifier, but as a principal licensee. So the statements were made in context to him being a principal licensee. And we would like to reaffirm that pursuant to the Act and the board's regulations, a GSP who does business under $100,000 may be required by the board to be registered or certified and its employees to maintain a permit or other authorization if the board determines that registration or certification is necessary to protect the integrity of gaming in this Commonwealth. And that's our position today, as it has been for years.
Thank you.
Thank you.
Any follow-up questions here? I think Tony had one. Okay, go ahead.
Yeah, if I may, a clarification and a question. Once again, you mentioned criminal charges, and you didn't say what the disposition of them.
They were null prost, which is, in lay terms, withdrawn.
Thank you. And that was my clarification. My question, you mentioned unique, that a family owns the casino. Could Nemacolin be considered the same circumstances where a family owns the casino?
That Nemacolin is not an issue here today. It's a different ownership structure.
Commissioner Muscata, if I may.
Yes, sir.
Let's start with the charges. The criminal charges, they were dismissed. They were null prost. There was an agreement between the DA's office and Mr. DeNaples that Mr. DeNaples would step away from the casino business. Okay?
Right.
And Those charges with no pros, Mr. DeNaples subsequently got an expungement of that record. Okay, that's the criminal charges. With regard to the uniqueness, it's not so much the family relationship, and you're right, family relationship could be looked at Nemacolin the same way, although Nemacolin does have a management company that runs that casino. The difference here is that Mr. DeNaples came before this board in 2006 seeking a principal license. He underwent a background investigation. During the course of that background investigation, a sworn interview was given by Mr. DeNaples under oath. That sworn interview was taken. Subsequent to that, Mr. DeNaples was issued a principal license by the board. Subsequent to that, the charges were filed. The charges allege that Mr. DeNaples perjured himself before this board. That was the last time a background investigation was done on Mr. DeNaples. That's where it stopped. Since that time, we've attempted numerous times in the course after the suspension was lifted to schedule a background investigation, sworn interview of Mr. DeNaples to no avail. An agreement was reached that once Mr. DeNaples would turn over everything to his family, that he would step away from the casino business, we would allow his license to expire. That is what took place. Subsequent to that time, Mr. DeNaples has come before this board either through Mount Airy, seeking the relief from these conditions. Mr. Grad is here today on behalf of Mr. DeNaples. Before Mr. Grad, other counsel came before this board on behalf of Mr. DeNaples seeking relief. Today, Mr. Grad is seeking an interpretation. It is up to the board to interpret its order. We respectfully request that the board interpret the order in a fashion that requires that Mr. DeNaples be prohibited, or any of his companies be prohibited from doing business with any licensed facility without going through the vetting process. I mean, that has been our position since day one. If Mr. DeNaples' company files an application, he submits himself to a background investigation, we will go through the process. The results will be given to this board for it to make a decision with regard to the suitability of that company and Mr. DeNaples. Even if the board interprets the order today to say that it does not prohibit Mount Airy from doing business with Louis DeNaples Company, we're going to be right back here the day after. Day one that they do business with a company, we will be right here before this board requesting that this board have that company file an application, have Mr. DeNaples file a qualifier application, and go through vetting. As soon as he's fingerprinted or any notification is filed, we're going to probably seek a termination or not authorize him to do any business until that vetting occurs. We're going to be right back here before this board. Okay, so you might interpret it that way today, but it's not going to solve the issue. You're just kicking the can down the road. Okay, if you interpret it our way, Mr. Grad's going to likely appeal to Commonwealth Court, which it wouldn't be the first time this has happened. So I'm here to you today to tell you that regardless of the outcome today, this issue will continue.
Were there any other questions from the
All right,
board?
thank you.
I really appreciate your presentation. That helps to clarify things well for me. Anything further at this point? Thank you very much. We will go into executive session a little later before we rule on this matter.
Thank you.
Moving on, could we have the representatives of El Dorado, Isle of Capri, come forward? Wow.
That's fine.
That's quite a lineup you've got there. I would ask before we begin, since I seem to have an entire baseball team assembled in front of me, I'd ask anyone who's going going to speak or thinks they may be speaking today, attorneys or otherwise, to please stand and state and spell your name for the court reporter. That includes attorneys for this moment. So just start, if you would, sir.
Gary Hendricks, Hendricks, Vice President and General Manager of Lake Elect Nemacolin.
Thank you.
Jeff Favre, Favre, Vice President, General Manager of Presque Isle Downs Casino.
Matthew Ennis, Ennis, Director of Finance, Presque Isle Downs Casino.
Thank you.
Glenn Carano, Carano, General Manager of 3 properties in Reno, Nevada.
Thank you.
Good morning, Mr. Chairman. Stephen D. Schreier with law firm of Blank Rome on behalf of the petitioner. And I would also add Michael Whitemane, who is behind me, who is the Senior Vice President of Operations of the Eastern Division of El Dorado.
Thank you. And for those of you who are not attorneys, if you remain standing and please be sworn in at this time by the court reporter.
Do you swear or affirm the testimony you're about to give this morning will be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, thank you very much.
Mr. Chairman, while we're still introducing, I would also like to note that counsel for Isle of Capri, Tammy Steinberg, is here from the Plaster Greenberg firm, and also Elizabeth Tranchina, who is the Vice President of Legal Affairs and Compliance from Isle of Capri. She's also here. And Michael Fabius, who is counsel for Woodlands Fayette, which is Nemacolin Resort, is also here on behalf of the Category 3 license holder, Woodlands Fayette. So I think now...
I think we've covered the universe now, have we?
I'm
Okay.
looking around the room, but maybe somebody else.
Well, if you discover somebody else, if you'd let us know, that'd
Thank you.
be lovely. The petitioners may proceed, please.
Thank you, Mr. Chairman, members of the commission, and board staff. As I indicated, my name is Stephen D. Schreier, and I am here on behalf of the petitioner, El Dorado Resorts Incorporated. Thank you for the opportunity to be here today to present this petition to you, seeking your approval to have El Dorado Resorts Incorporated acquire Isle of Capri Casinos Incorporated, which is the parent company of IOCPA LLC. IOCPA LLC is a licensed management company here in Pennsylvania, and they manage the casino at Nemacolin Woodlands Resort. We've now introduced all of our representatives, and I think just for clarification, if that's not enough, there actually is a current hearing going on today in Missouri on this same acquisition. El Dorado Resorts was not licensed in Missouri, but because of this acquisition of Isle of Capri, has to get licensed in Missouri. So, unfortunately, several of the key management team members who are not licensed in Missouri had to be at that hearing today instead of this one, and they wish they could be in both, but obviously they cannot.
I don't think we had room for them.
What's that? If you had room.
Would have had to
correct.
rent a hall.
If you had room. So these are the last 2 approvals of states for this acquisition, and today what I'd like to do is just summarize what the petition says and what you'll hear today. In essence, these are 2 very significant gaming operators, both of whom are publicly traded companies. They have substantial assets, and they're coming together with El Dorado actually acquiring Isle. Of note, for this particular petition, both of these companies are currently licensed here in Pennsylvania. El Dorado Resorts is the parent company of Presque Isle Downs, which is a Slot 1 licensee. And as I mentioned before, IOCPA is a licensed management company under the board's requirements. So the fact that they're both already properly licensed here in Pennsylvania for both of their respective operations kind of simplifies things enormously in our process. The petition that we have before you seeks approval of this change of control of the parent company of IOCPA, which is a management company licensee, and that approval is required under your regulations 440A6. Since El Dorado announced this merger in September of 2016, the two companies have been working closely with the board staff, with BIE, with OEC, to provide all of the information necessary to comply with the board's requirements. And I want to thank the board and its licensing staff and OEC and BIE for all of their assistance and patience and efforts in this process. What you'll hear this morning is the background of the company, the basic terms of the transaction, and the effect of this deal on these two gaming operations in the Commonwealth. At the conclusion, I believe you will conclude, as we have, that these companies are fully qualified, suitable, and that they meet the board's licensing requirements, and also that the combination of these two operations, one a management company license and the other a Category 1 slot licensee, will not create any anti-competitive or monopolistic concerns within Pennsylvania, which is one of the requirements that you must look at when you consider a change of control of a management company. So to start off, I would like to ask Glenn Carano to provide you with some background. Glenn currently holds a principal license, and before he got into the gaming industry, he was a quarterback for the Dallas Cowboys, but then, like many of us, saw the light and got involved in the gaming industry after that. In the coming days, he will be taking over the position after this closing as the Senior Vice President of Operations of the Eastern Division, which will cover Pennsylvania, West Virginia, and Ohio. And Michael Whitemane, who I introduced earlier, who is currently the Senior Vice President of Operations in this region, will be moving to the Southern Division. So, thank you for your time, and Glenn, take it away.
Thank you. Mr. Chairman, members of the board, thank you very much for giving us the opportunity to come before you today. It's great to be back in Pennsylvania in a friendly environment. My previous career, coming back to Pennsylvania, it wasn't always a friendly environment against your Eagles, and specifically the Steelers. They had our number back in the old days.
Sound familiar? Boo!
don't throw stuff at us, you know. But I did finish my career up in Pittsburgh with the Pittsburgh Maulers. So I was a Pittsburgh Mauler quarterback, and it was a great experience, albeit lived in Pittsburgh and in Pennsylvania for a little bit over a year and enjoyed the Pittsburgh area tremendously. Can you imagine a Dallas Cowboy quarterback getting a warm welcome there? I actually did. It was a nice time. But at any rate, again, it's exciting times for our company, and so I'm going to take you through a timeline here of how we got to where we are today. Okay, there you go. These things are fun, by the way. One more time. Okay, so this slide will show you that my father, Don Carano, a lawyer by profession, and Jerry Poncia, he's our architect. They started the El Dorado back in 1973 with 282 rooms, 500 slots, 20 table games. And as you see through the presentation, when we get the Isle of Capri acquisition done, we'll have over 20,000 slot machines, 550 table games, 6,500 hotel rooms. So this timeline started as we're a small company, and it's real exciting where we're going as a public company. And between 1973 and 1995, the El Dorado continued to grow, and then 1995, with a joint venture with MGM, we opened up the Silver Legacy in downtown Reno with 1,700 rooms, 1,300 slots, 70 table games. And if you haven't been to Reno and seen our property, you must come. But the tri-property, the Silver Legacy combined the El Dorado with 800 rooms in, and Circus, it combined it all, 1,500 rooms. It combined to make it a mega resort in downtown Reno of over 4,000 hotel rooms, 4,000 employees, 3,300 slot machines, and 130 table games. So it is the mega resort in downtown Reno. And then as the timeline goes, in 2005, we went on and acquired Eldorado Shreveport. Mr. Mike Whitemane, who's been working with the Eldorado for 37 years, went down and took over Eldorado Shreveport and managed that. And that has 400 rooms and 1,300 slot machines and 36 table games. In 2013, we announced a merger with MTR Gaming, which brought us east. And as it brought us east, it got us into the racing business, horse racing business, as we acquired Scioto Downs, Mountaineer, and your Presque Isle Downs up in Erie. And then that added another 5,500 slot machines to our portfolio. 2015, we then went back and bought the rest of Civil Legacy's 50% joint venture from MGM, and Circus Circus was also owned by MGM. We bought Circus Circus, so now we own the entire, in 2015, we own the entire tract properties in downtown Reno. 2016, just last year, we entered into a definitive agreement with Isle of Capri to acquire 12 more casinos. And those 12 more casinos, again, will add, which again, acquired 12 more casinos, one of which is the management contract with Lady Luck and Nemacolin. That'll add another 12,000 slot machines. So you'll see that through this whole presentation, it's a great growth pattern, great growth story, and we appreciate your support on helping us through this. At this time, I'd like to take it to the second slide here, next slide, which, there you go, and turn it over to Matthew Ennis. He's our Director of Finance in Presque Isle, and he'll take you through the transaction.
Thank you, Glenn. Going over some of the topics relative to the overall transaction. First, we begin with the transaction consideration. This bullet point is relative to the existing shareholders with the Isle. Eldorado Resorts will acquire the Isle of Capri for $23 per share as a set stock price. The shareholders do have the option to elect cash or stock consideration for each share of stock they own in the Isle. The election is subject to proration procedures so that the aggregate consideration will net out to 58% cash and 42% stock. Upon completion of the merger, the Eldorado shareholders will own approximately 62%, and the Isle shareholders will own approximately 38%. So that's just a general oversight as to the transaction consideration relative to outstanding shares for our holders. The value of the overall transaction is total purchase price for the Isle of $1.7 billion. This is inclusive of retiring $929 million of debt that the Isle is currently carrying on their books. The majority of the residual use of funds from the financing, to be explained below, will be used for the Isle equity purchase price transaction itself. At the time of the transaction, we are anticipating an acquisition multiple of 8.8 times. What that means is this is calculated as a total Isle purchase price of the $1.7 billion divided by $194 million, which is the last 12 months of EBITDA for Isle. So taking the 1.7 divided by the 194 gives us that 8.8 multiple. We anticipate improvements of that multiple going from 8.8 to 7.4 as a result of synergies we're anticipating as a result of the merger. We have identified $35 million of estimated identified cost synergies in the first year. This calculates as a $1.7 billion divided by the $194 million after adding back the $35 million in estimated cost synergies in year one. As far as the overall financing, we have secured the financing with JP Morgan, and the transaction will be financed with 3 additional pieces of debt on the overall Eldorado balance sheet. That consists of $1.4 billion of a 7-year term loan, a $375 million 8-year new senior unsecured note, and a 5-year $300 million revolving loan. That $300 million revolving loan, we anticipate borrowing $29 to $40 million at the time of the merger to close the final deal. Management and governance. Eldorado CEO and President and CFO will maintain their positions. We will also be designated 2 additional board members to the overall Eldorado board. The approval process, Eldorado and the Isle shareholders have already approved the merger on January 25th, 2017. You'll see the multiple states listed that have also approved the transaction itself. Obviously, the reason we're here today is to get Pennsylvania's approval, and as Glenn mentioned, we are anticipating Missouri's approval as well today. Timing, the transaction we are expecting to close in Q2 of 2017, subject to customary closing conditions as we work through the final merger. What this means is excitement for El Dorado, the increased scale and geographic diversification. With this anticipated merger comes the creation of a $3 billion premier regional gaming company, which in itself is exciting. Meaningfully increasing the El Dorado footprint to 19 regional gaming facilities in 10 states. Doubling El Dorado's net revenue and EBITDA overall as a company. The combined company to operate more than 20,060 slot machines and VLTs, more than 550 table games, and approximately 6,500 hotel rooms. The earnings growth and operational efficiencies that the combination of the Isle and El Dorado will bring, as previously mentioned, $35 million in annual run rate cost synergies in year one we are anticipating. We see a potential for further revenue and profitability upside. How so is because we will be able to share best practices across the companies to drive operational enhancements as we move further past the merger. The last two bullet points are relative to cash flow. At the time of the merger, we are expecting a net leverage ratio, which is net debt divided by EBITDA of the overall company of 5.4%. Utilizing the company's free cash flow to reduce the leverage and the continued disciplined maintenance and investment capital spending over the medium and long term, we are shooting for an objective to have our target long-term leverage ratio to be below 5.0%.
Thank you, Matt. This next slide will show how, and I'm going to take through a timeline here, but it shows how we actually fill in the entire country here. So, again, 1973, we started out with a white dot over in Reno, Nevada, and we had one casino there, and then in 1995, we went into 3 casinos. Then our next purchase was down in Louisiana. Then the acquisition of MTR and got the Scioto Downs in Ohio, West Virginia, Mountaineer, and Presque Isle. And then this new transaction is the darker dots that helps us fill in the rest of the country. So we got 2 casinos in the Rockies in Black Hawk, Colorado. We have 2 casinos there in Iowa, 4 casinos in Missouri, and another 2 casinos in the South Mississippi, and 1 casino on the eastern seaboard down there. I guess you call it Florida, eastern seaboard. And so we got one down there in Pompano. So we're excited that we now have become a major regional gaming company across the United States. Our next slide here, this is the current structure of our ownership of El Dorado Resorts Incorporated. Recreational Enterprises on the left is my family's corporation. Next to it, Hotel Casino Management is Jerry Ponce, my father's partners corporation. Par Investment is an institutional investor. They're actually invested in El Dorado Resorts Incorporated now and also Isle of Capri. The other 2 are investment institutional investors. So this makes this up. The yellow blocks on there are the individual casinos. And so we have 3 casinos, actually 4 casinos here underneath El Dorado, including Silver Lake, El Dorado Circus, and Shreveport. And then MTR, another subsidiary, has the 3 properties that we acquired from MTR: Scioto Downs, Presque Isle, and Mountaineer. This Isle Capri's current ownership, the Goldstein family, again, we share a lot of the same values as the Goldstein family. We believe in developing a great relationship, with our employees and our guests alike. In fact, I go back and say Mike is a 37-year veteran with the El Dorado. We have Mike Whiteman, that is, and we have a number of employees that have been with us from day one at the El Dorado Reno and also Silver Legacy. So we're all about taking care of our employees and developing a great relationship with both our employees and guests. And the Isle Capri, we feel, has that same value system as Bernie Goldstein started Isle Capri, and their families kept that up. They had, again, their ownership. Park Capital Management is invested in both companies. In the yellow box there, you'll see the 12 casinos, including Lady Luck Nemacolin, that will be part of the new company. Okay. Next slide here, again, brings us to the El Dorado Resorts. Executing Director of Enterprises is the Corona Family Hotel Inc., Jerry Poncia, and then you'll see that the Goldstein family is still a big part of our company. And then there we have 19 yellow boxes, which makes up 19 of our casinos facilities. The red box is Lake Charles in southern Louisiana that is actually we think is going to be divested from the company. Okay. What do I do? How do you do this? Excuse me. Oh, there you go. I pushed the right button. This slide right here is to show you the combined revenues and impact on the Pennsylvania gaming. This actually comes from some of your board documents, and so Prescott and Lady Luck Nemacolin jointly generated 6.2% of the Commonwealth's gross terminal revenue, 2.29% of the table game revenue, for 5.19% of the total gross gaming revenue. Combined, that's $167 million. That places us in 10th place in the overall. There's 9 Pennsylvania casinos that individually are ahead of the combined efforts of Prescal and Lady Luck. Not bragging about that. We'd like to be higher, but the point here is that, as you can see, there is no undue concentration of gaming monopolistic here. All right. At this time, I'd like to turn it over to our Vice President, General Manager of Prescal, Jeff Favre, and have him take you through the Prescal.
Thank you, Glenn. Mr. Chairman, board members, as always, pleased to be here. We're going to be continuing to focus on business as usual, primarily focused on driving or generating more revenue. And since El Dorado has taken over, I can tell you that their focus and their commitment to the capital injection into the property and improving the physical plant, refreshing the slot product, making the guest experience a more delighting, more pleasurable experience has certainly been gratifying and positive for me. So they have given me the resources and tools to work with. It's my job to utilize those properly and continue to capture more revenue. As you all are aware, Ohio opening up certainly put a dent into our revenues, and recapturing those revenues is really what the focus is, as well as maintaining our backyard, so to speak, which is our Erie market. And that's what we'll continue to do and continue to be focused on. And it's always a pleasure to be here. Thank you.
Thank you, Jeff. At this time, I'd like to introduce you Gary Hendricks, Vice President, General Manager of Lady Luck Casino Nemacolin. Again, Gary's been with Isle since 2011 and been in this position at Nemacolin for a little bit over a year.
Thank you, Glenn, Chairman, board members. It's a pleasure to be here today. Saw many of you just a few months ago for my license renewal for the property, so very familiar with Lady Luck. We are very excited about this transaction as well. We're looking forward to being able to share best demonstrated practices and really move both properties forward. We're going to concentrate, similar to what Jeff just said, on business as usual, keeping us moving forward.
Thank you, Gary. So, in conclusion, your approval of this acquisition combines two great companies that complement each other as gaming operators. Both companies are already licensed in the Commonwealth. Both companies are experienced in operating efficient, successful gaming facilities. There's going to be a seamless continuation of both gaming operations by the seasoned general managers that you've just heard from. We have fulfilled the board's criteria for approval of the transaction. So in closing, we really appreciate your time today and appreciate your helping us move forward. Try to get through this thing as painless and as quickly as possible for you. Again, thank you very much for having me come back to Pennsylvania. I love it. And at this time, I'll turn it back over to Steve, and he'll do his conclusion for you.
I think from the petitioner's point of view, we have concluded our presentation. I would just ask, as a housekeeping matter, we had submitted certain documents in evidence. They were identified as petitioners exhibits 1 through 5, and at some point I would like to just have those introduced. And they are effectively the board's own data that supports slide 8, which Glenn just talked about, which reflects even the combined nature of the gross terminal revenue and the gross table game revenue, and some of the other calculations that would go into the board's review and analysis of the undue concentration regulation. So if you look at those, you'll see where we got the data, and you'll also see a chart where we go into a lot more detail than slide 8 about why this combination should not create any concern on your part about any domination of the marketplace based upon this management company and this Category 1 licensee.
Thank you. Any objection to moving that stuff into evidence from enforcement?
No objections.
Counsel? Thank you.
Thank you.
Consider it submitted. Any questions or comments from enforcement counsel?
Benjamin Farrell, Ferrell, Assistant Enforcement Counsel for the Office of Enforcement Counsel. OEC doesn't have any formal presentation, but we do have some questions for the petitioners at this time regarding the petition. First, on what date do the parties intend to close on this transaction?
I can answer that. We are trying to close it as soon as possible, but again, the second quarter, and hopefully early here soon.
And
so you think within the next few weeks, within the next 2 or 3 weeks?
I think that's reasonable. Again, what's today's date? Today's date is the 26th. So yeah, we're hoping so. Thank you.
And if you have this information, on what date does El Dorado plan on taking full control of Isle of Capri?
Again, that would hopefully take place right when we close. Yes.
Right at closing.
Now, at this time, will El Dorado be making any changes to Lady Luck's compulsive and problem gambling plan?
We plan on basically adopting all the plans that are in place right now. We plan on operating all of the Isle of Capri's as status quo going forth, and then as we go down the line, we'll be taking best practices of all of our properties and making the properties bigger and better.
And that would include the diversity plan and the internal controls?
Most definitely. Everything, we believe in that.
And as you're aware, Isle of Capri currently has a shared services agreement for its properties, and El Dorado currently has a shared service agreement pending before the board. Does El Dorado have any plans to assume that contract as well, or they plan on incorporating it into the one pending before the board?
I believe, again, we're going to go ahead and defer that until we get operating everything, and so we keep everything in place as is right now.
What type of a transition period? What kind of how long do you think it'll take you guys after closing to transition into full control of the property?
Well, again, we have our general manager here right now, and so as is, we don't see anything changing.
Okay.
But we're going to keep on operating status quo, and then we'll start getting in there. We have to learn the property and see what the change. So I don't know if there'll be any changes.
Okay.
Hopefully, any change we make will be for the better of the property and making more, generate more revenues and ultimately more tax revenues.
OEC has no further questions at this time. Additionally, though, OEC would request to amend the conditions set forth in its answer dated February 2nd, 2017. OEC first requests to remove conditions 2 and 6 from its answer. Second, OEC requests to amend condition 7 to read, "No closing or change of control or assumption of duties by Eldorado or Isle shall take place until such time that the board has approved the proposed acquisition and all necessary entities and individuals have been licensed by the board subsequent to the completion and submission of the related suitability report, which includes all necessary background investigation reports, or until such time that all necessary entities and individuals have submitted completed applications to the board." And finally, subject to the conditions set forth in the pleadings and as amended, OEC has no objection to the joint petition of Eldorado Resorts, Inc., Isle of Capri Casinos, Inc., and related entities for an order approving the transfer of interest in a management company license and ancillary relief pursuant to 58 PA Code Section 440A.6.
So I presume you have no other independent presentation to make at this time?
No.
Right. Having heard the statement from Enforcement Council, does petitioner have any comment on their statement at this point?
I believe that we're in agreement with the conditions that have been set forth by Enforcement Council. Obviously the company does not know exactly what will happen until it actually closes. So without having the benefit of the closing, we obviously will do whatever we can to meet those conditions. And I think, as I've discussed with the Office of Enforcement Council, we will keep them apprised as things, after the closing, as things do begin to take shape, if there's going to be any changes or modifications to any of the plans, diversity plan, problem gambling plans, those kinds of things. We'll work closely with board staff to make sure that everybody's aware of that and get approvals, whatever kinds of things we need.
Okay. Are there any questions or comments from the board at this time?
So I was delighted to hear that you have shared values regarding your employees and you like to take care of them. I know that you have to submit a diversity and inclusion plan. My question is, can any of you talk about what that diversity and inclusion plan, not what it is, but in the context of your shared values and taking care of your employees, can you talk about your efforts regarding diversity and inclusion?
What I'd like to is, if I can, have Jeff Favre, who's press gal, he could address that. I'm not sure our plan in Nemacolin, but I can tell you we have a plan throughout all of our casinos to make sure that as much as possible our population of our employees meets and exceeds in diversity what's local in the community. And but Jeff, if you got some answers.
No, as far as specifics of the plan, of course we submit it, and I think we were here for our license renewal approximately 2 years ago, and some of the questions that came up were certainly focused on diversity. And since that license renewal, I can assure you that we have certainly migrated in the positive direction as far as diversity is concerned. I don't have any specific numbers that I can quote to you today, but I can certainly get those to you. But from an ethnic percentage standpoint, our ethnic makeup of our team members certainly meets the makeup of the county and far exceeds it with a couple of the ethnic backgrounds, especially the Asian population. And as far as a lot of the other diversity requirements, we certainly do what we need to do and moving it in the right direction. We look at it every month, and it's something that we understand is very important, and we take it very serious, and we'll continue to do so.
And I might add that that information is submitted to our Office of Diversity, and I'm sure that Director Daniels could provide you with any numbers or percentages or any information as it relates to what's been happening at Presque Isle and at Nemacolin or any other facility in the Commonwealth.
Great, thank you.
Any other questions at this time? I want to thank you all for coming and for the very cogent presentation. We're going to vote on this matter later today in the Office of Chief Counsel section of their presentation. At this time, the board will take a recess. Can't say whether it's 5 minutes or 15 minutes to consider both matters that have been presented before us today. Thank you very much.
Should be the same as that.
By way of announcements, the board held an executive session yesterday, April 25th, to conduct quasi-judicial deliberations relating to the matters being considered by the board today. Additionally, the board went back into executive session to deliberate on the two matters we discussed earlier this morning. Under new business, we will hear from Dave Wren, Director of the Office of Financial Management. Good morning, Dave.
Good morning. I'm here today to provide an update of board expenses through the third quarter of fiscal year 2016-17, which was as of March 31st. Spending to date this fiscal year has totaled $27.3 million against a total appropriation of $40,169,000. Total expenses are up less than 1% from the same period of the prior fiscal year. Spending for the third quarter alone was $9.1 million, or 34% of the year-to-date total. Payroll expenses in the first three quarters totaled $23.8 million, or 87.3% of total spending for the fiscal year. Benefits as a percentage of salaries totaled 69%, up from 67% last year. Adjusting for timing differences, year-to-date payroll is essentially unchanged from last year despite rising payroll and salary and benefit costs. This is due to a reduction in the complement from an average of $299 last year to $293 so far this year. Operating and fixed asset expenses recorded in the third quarter totaled $1.3 million, bringing the year-to-date total to $3.5 million. Operating and fixed asset expenses combined comprised 12.7% of the year-to-date spending. Rentals and leases totaling $1.4 million is the largest category of operating expense to date and represents 40% of overall operating expenses. The second largest category for the fiscal year is services, which contributed slightly over $1 million, or 30% to operating expenses to date. This category includes expenses for directors and officers insurance, fees for fingerprints utilized in background investigations, and interagency billings, among other expenses. Finally, the third largest category of operating expenses at $344,000, or 10.3% of operating expenses, is other operating expenses. This includes subscription costs utilized by BIE for background investigations. That concludes my remarks.
Thank you very much. Any questions or comments from the board at this point? Thanks, Dave.
Thank you.
Doug Sherman.
Good morning, Chairman, members of the board. Today we have three petitions before you for consideration, including the two matters that you heard just a short time ago. The first petition before the board today is Louis DeNaples' petition for determination regarding two gaming control board orders. Specifically, as you heard, DeNaples is asking the board to affirmatively state that the conditions in the board's September 23rd, 2009 and June 13th, 2012 orders, which preclude Mr. DeNaples from directly or indirectly receiving remuneration from the Mount Airy Casino or its owners, does not apply to or does not prohibit Mount Airy from transacting businesses with a Louis DeNaples owned or affiliated corporation. As noted, oral argument was heard this morning. You've been provided with the pleadings and all documents of record, and the matter is now appropriate for your consideration.
Thank you. Are there any further questions or comments from the board before I ask for a motion? Hearing none, is there a motion?
Yes, Mr. Chairman, I move that the board grant Louis DeNaples' petition regarding the PGCB orders of September 23rd, 2009 and June 13th, 2012.
Thank you. Second. On this one, I would like to have a roll call if possible.
Chairman Barish?
No.
Commissioner Jewell?
No.
Commissioner Logan?
Aye.
Commissioner Moscato?
Aye.
Commissioner Ryan?
No.
Commissioner Santoni?
Aye.
Commissioner Young?
Aye.
The motion has failed to get a qualified majority vote as defined under the Act, and it acknowledged earlier would be required, and therefore the motion is not granted.
Thank you, Doug. Next.
The second petition before the board is that of Eldorado Resorts and Isle of Capri's related entities joint petition for the board to approve the acquisition of Isle of Capri by Eldorado. As indicated, Eldorado is purchasing IOC, whose wholly owned subsidiary, IOC PA LLC, is the management company for the Lady Luck Casino at Nemacolin. As the board heard earlier, the Office of Enforcement Counsel does not oppose the granting of the petition, subject to certain conditions as were discussed by the parties. And those are primarily requiring the parties to keep BIE informed as the transaction progresses, as well as providing a number of documents and applications. The record is closed, and it's ready for your consideration.
Questions or comments from the board at this point? May I have a motion?
Mr. Chairman, I move that the board grant Eldorado Resort Inc.'s Isle of Capri Casino Inc. and their related entities joint petition for approval of a transfer of interest in a management company licensee with certain of the conditions requested by the Office of Enforcement Counsel. I further move that petitioner's request for confidentiality be granted.
Second.
All in favor?
Aye.
All opposed? The motion's adopted.
The final petition before the board pertains to the Office of Enforcement Counsel's request to revoke Xiao Kui Lee's gaming permit. Mr. Lee has waived the right to a hearing, and therefore the board can decide the matter based upon the documentary record. The uncontested facts in the matter show that on May 15, 2015, Mr. Lee, who was employed as a table game dealer at Sands Bethworks, was arrested and charged with simple assault and disorderly conduct resulting from an altercation between himself and a patron outside the Sands in the parking lot. Mr. Lee was terminated from his employment with Sands as a result of the situation, and he is not presently employed by any Pennsylvania casino. In July 2015, the Office of Enforcement Counsel filed a complaint to revoke Mr. Lee's gaming permit. He initially requested a hearing on the matter, but subsequently signed a waiver of the right to a hearing, thereby allowing the board to decide it based upon the documentary record. It's this matter which is now ready for the board's consideration.
Questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board grant the Office of Enforcement Counsel's request to revoke Xiao Kui Lee's gaming employee occupation permit as described by the Office of Chief Counsel.
Second.
All in favor?
Aye.
All opposed? Motion's adopted.
Next, presenting withdrawals and reports and recommendations is Deputy Chief Counsel Steve Cook.
Good morning. I think the board has received several unopposed petitions to withdraw the applications or surrender the credentials of the following individuals: Bernard Lope, Brooks Harrison Pierce, Herbert Lugmeyer, Ian Guy Handley Ashkin, Richard Todd Sanson, and Roger A. Davis. The Office of Enforcement Counsel has no objections to any of these withdrawals or surrenders, and as a result, if the board grants same, they would be doing so without prejudice to each of these persons. And the matters are all right for the board's consideration.
Thank you. Questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board issue orders to approve the withdrawals and surrenders as described by the Office of Chief Counsel.
Second.
All in favor?
Aye.
All opposed? Motion's adopted.
Next before the board for consideration are two reports and recommendations received from the Office of Hearings and Appeals. These reports and recommendations, as well as the complete evidentiary record in each matter, have been provided to the board in advance of today's meeting. And additionally, in both of these cases, the gentlemen that are the subject of the two reports and recommendations have been notified that the matter would be taken up by the board today and that they could come forward and briefly address the board before the vote. If either of these individuals are present today, I'd ask them to come forward when their matter is called. The first report and recommendation pertains to Zai Lee. The board renewed Mr. Lai's gaming permit in 2014, and he worked as a table games dealer at Harrah's, Philadelphia. On December 2nd, 2017, the Office of Enforcement Counsel filed a request for an emergency suspension of Mr. Lay's gaming permit and after receiving notice that he'd been arrested and charged with several criminal offenses, including a number of felony counts. Specifically, it is alleged that in an effort to collect a debt, this individual pulled a firearm on another individual and struck him in the head numerous times. He did this on 2 occasions. And as a result of these allegations and the charges that were filed subsequent thereto, the executive director issued an emergency suspension as requested by Enforcement Counsel. Subsequently, a hearing on the validity of the emergency suspension was held at the Office of Hearings and Appeals. OEC and Mr. Lay both appeared at the hearing. OEC presented evidence indicating that the criminal charges were filed and what the underlying allegations were. Mr. Lay testified only that he was innocent of the charges and felt he should have his license reinstated as such. Notwithstanding that testimony, the hearing officer recommends that the suspension remain in place because the felony charges continue to be lodged against this individual, and that's the recommendation before the board.
Questions or comments from the board? May I have a motion?
Mr. Chairman, I move the board adopt the report and recommendation issued by the Office of Hearings and Appeals regarding the suspension of Zai Lay's gaming employee occupation permit as described by the Office of Chief Counsel.
Second.
All in favor?
Aye.
All opposed? The motion's adopted.
The second and final report and recommendation before the board today stems from a request to be removed from the voluntary self-exclusion list. Pursuant to the findings of fact in the report and recommendation issued in this matter, on September 16, 2010, an individual with the initials RN entered the Hollywood Casino, met with the casino compliance representative, and requested to be placed on the lifetime self-exclusion list. The casino compliance representative thereafter conducted the mandatory interview with RN and completed all of the required procedures. Thereafter, RN signed an acknowledgement form selecting lifetime self-exclusion. On November 29, 2016, approximately 6 years later, RN filed a request to be removed from the voluntary self-exclusion list, stating he placed himself on the list originally because his frequent trips were causing marital problems, and he believed he would only be excluded from Hollywood Casino rather than all of the casinos across the Commonwealth. Petitioner now alleges that he is now retired and would like to again visit casinos. The Office of Enforcement Counsel filed an answer objecting to RN's request, and a hearing was held on February 8, 2017. Despite receiving notice, RN did not appear at the hearing. As a result, only Enforcement Counsel put in evidence. RN did not meet his burden, and ultimately the report and recommendation issued recommends that he remain on the self-exclusion list.
Thank you. Any questions or comments from the board? May I have a motion?
Chairman, I move that the board adopt the report and recommendation issued by the Office of Hearings and Appeals regarding RN's petition for removal from the self-exclusion list as described by the Office of Chief Counsel.
Second.
All in favor?
Aye.
All opposed? Motion's adopted.
That concludes the matters of the Office of Chief
Thank
Counsel.
you. Bureau of Licensing. Sean Hannon.
Thank you, Chairman, members of the board. Before the board today will be licensure related to a Category 3 management company change of control, one slot machine manufacturer renewal license, one gaming junket enterprise, and 600 principal key gaming and non-gaming employee applicants. In addition, there will be consideration of 16 gaming service provider applicants. The first matter for your consideration are principal licenses associated with the change of control of IOC-PA LLC. IOC-PA LLC is a management company for Woodlands Fayette LLC doing business as Lady Luck Casino Nemacolin. Under the change of control, IOC-PA LLC's parent company will be acquired by Eldorado Resorts Incorporated, a principal affiliate and ultimate parent company of Category 1 slot machine licensee Presque Isle Downs. Pursuant to board requirements for approval of a change of control, certain entities and individuals associated with the acquisition are required to be licensed as principals by the board, including two entities, Eagle One Acquisition Corp. And Eagle Two Acquisition Corp. LLC, both subsidiaries of Eldorado Resorts Incorporated, as well as certain individuals. The Bureau of Investigations and Enforcement has completed its investigation of the principals, and the Bureau of Licensing has provided you with the background investigation and suitability report. I have provided you with the draft order and asked the board to consider the licensure of the required principals.
Enforcement Counsel?
No objection.
Thank you. Questions or comments from the board? May I have a motion?
Mr. Chairman, I move the board approve licensure of the principals associated with IOC-PA LLC's approval for change of control as described by the Bureau of Licensing.
Second.
All in favor?
Aye.
All opposed? Motion's adopted.
Next for your consideration is the renewal of the Every Games Incorporated slot machine manufacturer license. The Bureau of Investigations and Enforcement has completed its investigation of the company, and the Bureau of Licensing has provided you with a background investigation and suitability report regarding the renewal. I have provided you with a draft order for this entity and ask that the board consider the order to renew the slot machine manufacturer license.
No objection.
Thank you. Questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board approve the slot machine manufacturer license renewal for Every Games, Inc., as described by the Bureau of Licensing.
Second.
All in favor?
Aye.
All opposed? Motion's adopted.
Also for your consideration is the approval of the Gaming Junket Enterprise license for MES Travel and Junkets Incorporated. The Bureau of Investigations and Enforcement has completed its investigation of this company, and the Bureau of Licensing has provided you with the background investigation and suitability report for this applicant. I have provided you with a draft order and ask that the board consider the approval of the license for MES Travel and Junkets Incorporated.
No objection.
Questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board approve MES Travel and Junkets, Inc.'s Gaming Junket Enterprise license as described by the Bureau of Licensing.
Second.
All in favor?
Aye.
All opposed? Motion's adopted.
Next for your consideration is the approval of principal and key employee licenses. Prior to this meeting, the Bureau of Licensing provided you with a proposed order for 11 principals and 12 key employee licenses. I ask that the board consider the order approving these licenses.
No objection.
Questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board approve the issuance of principal and key employee licenses as described by the Bureau of Licensing.
Second.
All in favor?
Aye.
All opposed? Motion's adopted.
Next are temporary key employee licenses. Prior to this meeting, the Bureau of Licensing provided you with an order regarding the issuance of temporary licenses for 7 key employees. I ask that the board consider the order approving these licenses.
No objection.
Questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board approve the issuance of temporary key employee credentials as described by the Bureau of Licensing.
Second.
All in favor?
Aye.
All opposed? Motion's adopted.
In addition, there are gaming permits and non-gaming registrations. Prior to this meeting, the Bureau of Licensing provided you with a list of 360 individuals to whom the Bureau has granted temporary or full occupation permits, and 184 individuals to whom the Bureau has granted registrations under the authority delegated to the Bureau of Licensing. I ask that the board consider a motion approving this order.
No objection.
Questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board approve the issuance of gaming employee permits and non-gaming employee registrations as described by the Bureau of Licensing.
Second.
All in favor?
Aye.
All opposed? Motion's adopted.
Also, there are recommendations of denial for 1 gaming service provider, 1 gaming, and 2 non-gaming employee applicants. In each case, the applicant failed to request a hearing within the specified timeframes. The Bureau of Licensing has provided you with orders addressing the applicants who the Office of Enforcement Counsel has recommended for denial. I ask that the board consider a motion approving the denials.
The Office of Enforcement Counsel will request denial in each instance. Additionally, with regard to the gaming service provider, the Office of Enforcement Counsel will request that gaming service provider be placed on the prohibited gaming service providers list.
Questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board deny the gaming service provider, gaming and non-gaming employee applications as described by the Bureau of Licensing.
Second.
All in favor?
Aye.
All opposed? Motion's adopted.
Also for your consideration are withdrawal requests for gaming and non-gaming employees. In each case, the permit or registration is no longer required. For today's meeting, I have provided the board with a list of 18 gaming and 4 non-gaming employee withdrawals for approval. I ask that the board consider the order approving the list of withdrawals.
Enforcement Counsel has no objection.
Questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board approve the withdrawals as described by the Bureau of Licensing.
Second.
All in favor?
Aye.
All opposed? The motion's adopted.
Next, we have an order to certify the following gaming service providers: BV Bethlehem LLC, Hispanic Ventures Incorporated, Cornercom Incorporated, Paragon Wholesale Foods Corporation. I ask that the board consider the order approving these gaming service providers for certification.
Enforcement Counsel has no objection.
Question or comments from the board? May I have a motion?
Mr. Chairman, I move that the board approve the applications for gaming service provider certification as described by the Bureau of Licensing.
Second.
All in favor?
Aye.
All opposed? Motion's adopted.
Finally, for your consideration are gaming service provider registrations. The Bureau of Licensing provided you with an order and an attached list of 12 registered gaming service provider applicants. I ask that the board consider the order registering these gaming service providers.
Enforcement Council has no objection.
Questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board approve the applications for gaming service provider registration as described by the Bureau of Licensing.
Second.
All in favor?
Aye.
All opposed? Motion's adopted.
That concludes the Bureau of Licensing matters.
Thank you, Sean. Next up, Office of Enforcement Counsel, as we begin.
The Office of Enforcement Counsel will present 15 matters today for the board's consideration, consisting of 3 consent agreements, 3 revocations, and non-involuntary exclusions. First matter on the Office of Enforcement Counsel's part of the agenda is for the board's consideration is a consent agreement between the Office of Enforcement Counsel and Category 3 management company IOC PA LLC doing business as Lady Luck Casino through the Category 3 license issued to Woodlands Fayette LLC. The matter will be presented by Assistant Enforcement Counsel Benjamin Farrell. Representatives for Lady Luck are present today. I request that those individuals introduce themselves for the record, and if necessary, stand and be sworn. I think Mr. Hendricks was sworn earlier.
Sworn in, yeah. It's Gary Hendricks, Vice President and General Manager, HENDRICKS.
Elizabeth Tranchino, Vice President of Legal Affairs, Isle of Capri Casinos, Inc.
You're in here in his capacity as attorney?
Yes.
Thank you.
Chairman, members of the board, on January 16th, 2017, the Bureau of Casino Compliance was not timely notified of IOCPA's removal of an intoxicated patron from its gaming floor. A surveillance review of the incident revealed that the patron was served and consumed 12 alcoholic beverages from 3 different beverage servers between 2:03 p.m. and 10:11 p.m. The patron gamed between 2:05 p.m. and 11:15 p.m. At approximately 11:15 p.m., a security supervisor performed a wellness check of the patron, determined the patron was intoxicated, and provided that patron coffee and food. The patron was allowed to leave the facility at 11:56 p.m. An hour and 58 minutes elapsed before the Bureau of Casino Compliance was notified. No entries were made in IOCPA's dispatch log regarding any notifications made to Bureau of Casino Compliance and Pennsylvania State Police regarding this incident. Under the terms agreed upon by both parties, IOCPA would pay a civil penalty of $15,000 as well as an investigative fee of $2,500. At this time, OEC requests that the board approve this consent agreement.
Thank you. Any comments from Isle of Capri?
No.
Okay. Any questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board approve the consent agreement between the Office of Enforcement Counsel and IOCPA LLC as described by the Office of Enforcement Counsel.
Second.
All in favor?
Aye.
All opposed? Motion's adopted. Thanks for
Thank you, Chairman and Commissioners.
Thanks for sticking around.
Next matter on the agenda for the board's consideration is a consent agreement between the Office of Enforcement Counsel and Richard M. Linskold II. The matter will be presented by Assistant Enforcement Counsel James Armstrong. If Mr. Linskold and his representative is here, I'd ask that they come forward and be sworn.
They're not here.
They're not here.
Good morning, Commissioners, Chairman. James Armstrong for the Office of Enforcement Counsel. Commissioners, the next matter for the board's consideration is a consent agreement reached between the Office of Enforcement Counsel and Richard Linskold in regard to a petition to place Mr. Linskold on the board's involuntary exclusion list. Commissioners, on August 26 of 2016, a table game supervisor at Sugar House Casino became suspicious of Mr. Linskold being underage in the casino. A security check determined that Mr. Linskold's ID was a fake Connecticut driver's license. Security questioned Mr. Linskold about his identification. Mr. Linskold admitted that the identification was false. A review of surveillance coverage revealed that Mr. Linskold gambled on roulette and blackjack games at Sugar House for 33 minutes before he was confronted by security and escorted off the casino floor. The Pennsylvania State Police issued Mr. Linskold a citation for being on the gaming floor underage, and he was issued a formal eviction notice by Sugar House Casino. As a result, OEC filed a petition to place Mr. Linskold on the board's involuntary exclusion list. Subsequently, Mr. Lenskold, through his counsel, reached a consent agreement with OEC in this matter. OEC and Mr. Lenskold requested the board approve the consent agreement and stipulation of settlement entered into between the parties to resolve the exclusion petition. The terms of the settlement include provisions that Mr. Lenskold will be placed on the board's involuntary exclusion list until at least his 22nd birthday, or 1 year after the board's approval of the consent agreement, whichever shall occur last. Mr. Lenskold will be barred from petitioning the board for early removal from the exclusion list or requesting a hearing concerning his removal until the agreed-upon exclusion period has elapsed. Mr. Lenskold shall be ejected on-site from all licensed facilities. Mr. Lenskold is barred from receiving any winnings as a result of gaming activity, and Mr. Lenskold's photograph, physical description, date of birth, and a summary of his inimical conduct shall be placed on the board's public website. Should Mr. Lenskold file a petition to be removed from the exclusion list after his 22nd birthday or 1 year from the board's order, whichever shall occur last, OEC will not object to such removal, provided Mr. Lenskold has not been charged with any further gambling or gaming-related crimes, and he has not entered or attempt to enter any licensed facility in the Commonwealth. I'll be glad to answer any questions you may have.
Questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board approve the consent agreement between the Office of Enforcement Counsel and Richard M. Lenskold II as described by the Office of Enforcement Counsel.
Second.
All in favor?
Aye.
All opposed? The motion's adopted.
Next matter on the agenda for the board's consideration is a consent agreement between the Office of Enforcement Counsel and Sugar House HSP Gaming LP doing business as Sugar House Casino. The matter will be presented by Assistant Enforcement Counsel James Armstrong. Mr. Donnelly is here on behalf of Sugar House Casino, and I believe he has someone with him.
Yes. John Donnelly on behalf of Sugar House Casino. With me is Director of Surveillance Tom Scott.
Just the abundance of caution, Mr. Scott, would you stand and be sworn? Thank you.
Chairman, thank you. Commissioners, the next matter for the board's consideration is a consent agreement reached between OEC and Sugar House Casino in regard to the Sugar House Surveillance Department failing to make timely surveillance log entries and maintain a proper modified log entry reporting program. Commissioners, in October and November of 2015, the Bureau of Gaming Operations conducted a follow-up regulatory compliance assessment audit to its 2013 Sugar House Casino Gaming Operations Audit Report, which led to Sugar House amending its internal controls to address deficiencies in its surveillance department, amongst other areas. OEC's review of the Bureau of Gaming Operations 2015 follow-up audit report revealed that Sugar House may have committed regulatory and internal control violations in regard to the surveillance department's maintenance of the iTrack system surveillance daily log. OEC referred the matter to BIE for further investigation. BIE's investigation determined that violations of Sugar House's internal controls did occur in that Sugar House's surveillance department failed to notify or properly document the notification of Sugar House's security department when an equipment or camera malfunction occurred. Sugar House's surveillance department also failed to ensure that surveillance personnel did not make entries into Sugar House's iTrack system surveillance daily log under another individual's name or login account, and Sugar House failed to ensure that its iTrack system surveillance daily log denoted subsequent entries as changes or modifications to the original entry. As a result, Sugar House promptly upgraded its iTrack system to correct the issue. Additionally, surveillance department employees have been directed to notify the board's Bureau of Casino Compliance and the security department of any equipment and or camera malfunctions and to log the notification in the iTrack system surveillance daily log. Furthermore, all surveillance department shift managers have been instructed to monitor and review the iTrack system surveillance log entries at the end of each shift to ensure the logs are accurate. Surveillance department employees were also counseled to sign in and out on their own workstations and to log out if they leave the surveillance room for a period of time. If approved, Commissioners, this will be the first penalty assessed against Sugar House for violating provisions of the Act, regulations, or internal controls regarding surveillance department violations. The OEC and Sugar House requested the board approve the consent agreement and stipulation of settlement entered into between the parties. The terms of the settlement include a provision that Sugar House shall reinforce its policies and provide training and guidance to its surveillance department employees, which will minimize the potential for these violations to occur again. Sugar House shall also pay a $30,000 civil penalty and $2,500 for costs incurred by the board in regard to this matter.
Thank you.
Donnelly and I will be glad to answer any questions you may have.
Any questions or Any comments from Sugar House?
Only if there are questions from the commission.
Thank you. Any questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board approve the consent agreement between the Office of Enforcement Counsel and Sugar House HSP Gaming LP as described by the Office of Enforcement Counsel.
Second.
All in favor?
Aye.
All opposed? Motion's adopted. Thank you.
Thank you.
The next three matters on the agenda consist of enforcement actions in which the Office of Enforcement Counsel has filed complaints seeking the revocation of one gaming permit and two non-gaming registrations issued by the board. Each complaint has been filed with the board's Office of Hearings and Appeal and properly served upon the individual named in each complaint. The person named in each complaint failed to respond within 30 days as required by board regulation. As a result, the Office of Enforcement Counsel filed a request for default judgment and properly served the same upon each named individual. Therefore, the facts in each complaint are deemed admitted. All filed documents have been provided to the board, and the matters are presently ripe for the board's consideration. In each instance, we will provide a brief summary of the fact and request the appropriate board action.
Chairman, Commissioners, the next on the agenda for the board's consideration is a complaint to revoke Gregory Evans's gaming employee permit as a result of Mr. Evans being highly intoxicated while performing his job duties as a dealer at Sugar House Casino. As a result, Sugar House terminated Mr. Evans. Mr. Evans failed to maintain his suitability for licensure. He is not presently employed in any Pennsylvania casino. Accordingly, OEC requests the board revoke Mr. Evans's gaming employee permit.
Questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board approve the revocation of Gregory Evans gaming employee occupation permit as described by the Office of Enforcement Counsel.
Second.
All in favor?
Aye.
All opposed? Motion's adopted.
Thank you. Next on the agenda is a complaint to revoke Khalid McDaniel's non-gaming employee registration. While employed at Sugar House Casino, Mr. McDaniel was recorded on surveillance in the chip fill room taking $210 that did not belong to him. He was subsequently admitted the theft. Mr. McDaniel was terminated from Sugar House Casino and is not presently employed in Pennsylvania's gaming industry. Accordingly, OEC requests that the board revoke Mr. McDaniel's non-gaming employee registration.
Questions or comments from the board? Is there a motion?
Mr. Chairman, I move that the board approve the revocation of Khalid M. McDaniel's non-gaming employee registration as described by the Office of Enforcement Counsel.
Second.
All in favor?
Aye.
All opposed? The motion's adopted.
Thank you. Next on the agenda is a complaint to revoke Alencia Smith's non-gaming employee registration as a result of Ms. Smith failing to maintain her suitability for registration. Ms. Smith had recent arrests for prostitution and illegal drug possession offenses. Ms. Smith had a previous history of arrests with the Philadelphia Police from 1989 through 2005, including 3 prostitution arrests and convictions. Ms. Smith was terminated from Sugar House Casino for fighting and threatening coworkers. Ms. Smith is not presently employed in the Pennsylvania gaming industry. Accordingly, OEC requests the board revoke Ms. Smith's non-gaming employee registration.
Questions or comments from the board? Is there a motion?
Mr. Chairman, I move that the board approve the revocation of Valencia Malvina Smith's non-gaming employee registration as described by the Office of Enforcement Counsel.
Second.
All in favor?
Aye.
All opposed? Motion's adopted.
The remaining 9 matters on the agenda consist of enforcement actions in which the Office of Enforcement Counsel has filed petitions seeking the involuntary exclusion of individuals whose presence in the licensed facility are inimical to the interests of the Commonwealth and are licensed gaming therein. In each instance, the petition for exclusion has been filed with the Board's Office of Hearings and Appeal and properly served upon the individual named in the petition. The individual named in the petition failed to respond within 30 days. As a result, the Office of Enforcement Counsel filed a request for default judgment in each instance and properly served the same upon each named individual. Therefore, all facts in each petition are deemed admitted. All filed documents have been provided to the board, and the matters are presently ripe for the board's consideration. In each instance, if the board orders the proposed exclusion, each individual's photo, personal identifiers, and a summary of the inimical conduct will be placed on the board's public website.
Chairman, Commissioners, next on the agenda for the board's consideration is a request to place Montserrat de Leon on the exclusion list as a result of Mr. de Leon utilizing a false identification to access the gaming floor at Sugar House Casino while under the age of 21. Mr. de Leon was arrested by the Pennsylvania State Police and charged with violating Section 1518A13 of the Gaming Act, unlawful to permit a person under 21. Accordingly, OEC requests that the board place Mr. de Leon on the board's involuntary exclusion list.
Questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board approve the addition of Maserat de Leon to the PGCB involuntary exclusion list as described by the Office of Enforcement Counsel. I further move that Mr. de Leon may petition for removal from the list anytime after his 22nd birthday.
Second.
All in favor?
Aye.
Aye.
Opposed? The motion's adopted.
Thank you. Next on the agenda is a request to place Andrew Fisher on the exclusion list as a result of Mr. Fisher utilizing a fraudulent identification to access the gaming floor at Sugar House Casino while under the age of 21. Mr. Fisher was arrested by the Pennsylvania State Police and charged with violating Section 1518A13 of the Gaming Act, unlawful to permit person under 21. Accordingly, OEC requests the board place Mr. Fisher on the board's involuntary exclusion list.
Questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board approve the addition of Andrew Fisher to the PGCB involuntary exclusion list as described by the Office of Enforcement Counsel. I further move that Mr. Fisher may petition for removal from the list anytime after his 22nd birthday.
Second.
All in favor?
Aye.
All opposed? Motion's adopted.
Thank you. Next on the agenda for the board's consideration is a request to place Skylar McCunis on the exclusion list as a result of Mr. McCunis utilizing a fraudulent identification to access the gaming floor at Sugar House Casino while under the age of 21. Mr. McCunis was arrested by the Pennsylvania State Police and charged with violating Section 1518A13 of the Gaming Act, unlawful to permit person under 21. Accordingly, OEC requests the board place Mr. McCunis on the board's involuntary exclusion list.
Questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board approve the addition of Skylar E. McCunis to the PGCB involuntary exclusion list as described by the Office of Enforcement Counsel. I further move that Mr. McCunis may petition for removal from the list anytime after his 22nd birthday.
Second.
All in favor?
Aye.
All opposed? Motion's adopted.
Thank you. The next on the agenda is a request to place David Moore on the exclusion list as a result of Mr. Moore punching the glass face of a slot machine on the gaming floor at Sugar House Casino, breaking the glass and causing $495 in damages and failing to make restitution. Mr. Moore was arrested by the Pennsylvania State Police and charged with the summary offense of criminal mischief. Accordingly, OEC requests that the board place Mr. Moore on the board's involuntary exclusion list.
Questions or comments from the board? Is there a motion?
Mr. Chairman, I move that the board approve the addition of David M. Moore to the PGCB involuntary exclusion list as described by the Office of Enforcement Counsel.
Second.
All in favor?
Aye.
All opposed? Motion's adopted.
Thank you. Next on the agenda is the request to place Matthew Seaman on the exclusion list as a result of Mr. Seaman utilizing a fraudulent identification to access the gaming floor at Sugar House Casino while under the age of 21. Mr. Seaman was arrested by the Pennsylvania State Police and charged with violating Section 1518A13 of the Act, unlawful to permit person under 21. Accordingly, OEC requests the board place Mr. Seaman on the board's involuntary exclusion list.
Questions or comments from the board? Is there a motion?
Mr. Chairman, I move that the board approve the addition of Matthew Seaman to the PGCB involuntary exclusion list as described by the Office of Enforcement Counsel. I further move that Mr. Seaman be allowed to petition for removal from the list any time after 1 year.
Second.
All in favor?
Aye.
All opposed? Motion's adopted.
Thank you. Next on the agenda is a request to place Michael Gross on the exclusion list as a result of Mr. Gross utilizing a fraudulent identification to access the gaming floor at Sugar House Casino while under the age of 21. Mr. Gross was arrested by the Pennsylvania State Police and charged with violating Section 1518A13 of the Gaming Act, unlawful to permit person under 21. Accordingly, OEC requests the board place Mr. Gross on the board's involuntary exclusion list.
Questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board approve the addition of Michael T. Gross to the PGCB involuntary exclusion list as described by the Office of Enforcement Counsel. I further move that Mr. Gross be allowed to petition for removal from the list any time after his 22nd birthday.
Second.
All in favor?
Aye.
All opposed? Motion's adopted.
Thank you. Next on the agenda is a request to place Donald White on the exclusion list as a result of Mr. White leaving his 7-year-old son unattended in his vehicle in the parking lot at Sugar House Casino while he was in the casino for approximately 2 hours and 45 minutes participating in gaming activities. Mr. White was arrested by the Philadelphia Police and charged with endangering the welfare of children and recklessly endangering another person. Mr. White was found guilty of endangering the welfare of children, a first-degree misdemeanor. Accordingly, OEC requests the board place Mr. White on the board's involuntary exclusion list.
Questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board approve the addition of Donald White to the PGCB involuntary exclusion list as described by the Office of Enforcement Counsel.
Second.
All in favor?
Aye.
All opposed? The motion's adopted.
Thank you. Next on the agenda for the board's consideration is a request to place Michael Young on the exclusion list as a result of Mr. Young utilizing a fraudulent identification to access the gaming floor at Sugar House Casino while under the age of 21. Mr. Young was arrested by the Pennsylvania State Police and charged with violating Section 1518A13 of the Gaming Act, unlawful to permit person under 21. Accordingly, OEC requests the board place Mr. Young on the board's involuntary exclusion list.
Questions or comments from the board? May I have a motion?
Chairman, I move that the board approve the addition of Michael Young to the PGCB involuntary exclusion list as described by the Office of Enforcement Counsel. I further move that Mr. Young may petition for removal from the list after 1 year.
Second.
All in favor?
Aye.
All opposed? Motion's adopted.
Thank you.
Good afternoon, Chairman Barish, members of the board. Dustin Miller on behalf of the Office of Enforcement Counsel. The last matter today is a request for placement on the board's excluded persons list involving Shane Hickey. The Office of Enforcement Counsel filed a petition to place Mr. Hickey on the exclusion list for trying to obtain an access card to enter the gaming floor of Valley Forge Casino Resort while under the age of 21 by using identification that misrepresented Mr. Hickey's age. Mr. Hickey was charged by Pennsylvania State Police with carrying a false identification card for his actions. Based upon the foregoing, the Office of Enforcement Counsel asked that the board place Shane Hickey on the board's excluded persons list.
Questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board approve the addition of Shane Hickey to the PGCB involuntary exclusion list as described by the Office of Enforcement Counsel. I further move that Mr. Hickey may petition for removal from the list after 1 year.
Second.
All in favor?
Aye.
All opposed? The motion's adopted.
That concludes my business.
Thank you very much. That concludes today's business. Our next scheduled public session will be held on Wednesday, May 17th. The meeting will begin at 10 o'clock in this room. Are there any other final comments from the board or ex officio members? Hearing none, may I have a motion to adjourn the meeting?
Mr. Chairman, with some regret, I move that we adjourn the meeting.
Second.
All in favor?
Aye.
All opposed? The motion's adopted. Regret.
Yeah.
Regret. You want to keep